Well, welcome everyone to our brief overview of copyright law. My name is Trevor Reed, and I'll be walking you through the basics of copyright for Indigenous cultural materials. I'll first talk about the different kinds of intellectual property rights that are out there, and then I'll address some of the kinds of materials that qualify for copyright protection. And then I'll wrap up with a little bit about some of the limitations of copyright law for protecting Indigenous cultural materials. There are a lot of different kinds of IP. These range from patents that protect inventions to trademarks that protect brands and logos to things like trade secrets that protect recipes or production techniques or know-how that businesses tend to keep confidential. And also rights to privacy and publicity, which protect people's names, their likenesses, images, and sometimes even the sounds of their voice. Copyright, though, on the other hand, protects creative expression. Things like books, like movies, music, sound recordings, dance, architecture, photographs, and visual arts, to name just a few. So what is a copyright? Well, you may have heard about people mailing something to themselves via registered mail, or maybe putting this copyright symbol on something. Here's what a copyright really is. A copyright is a temporary and a limited right to keep others from doing certain things with a creative work that they own. A copyright is temporary. Like a plate of cookies, it's not going to last forever. And that can be a good thing. In some cultures in the world, the goal is for all knowledge, all ideas, all creativity to be accessible to everyone at any time without having to pay or ask permission. That isn't always the case, though, with the things that we create in Indigenous communities. Some of them have special rules or protocols or standards of care that have to be followed no matter how old the work is. Copyrights are also limited. Let's say I've just written an amazing novel. You can keep people from making copies of the book without your permission by upholding your copyright. You can keep people from making a movie from it and deriving new things out of it. You can keep people from distributing illegal copies of it on the internet. You can keep people from even reading or performing your novel in public or displaying the text on a billboard. But even though you have these rights, others can still use your work in ways that aren't covered by copyright or which fall under exceptions like fair use. They might be able to talk or write about your work in the media. They might be able to critique it. They might preserve it, or maybe make educational resources from it. They can use the facts, the histories, the ideas, the knowledge, the systems, and other non-creative aspects of your work without your permission. It's important to point out that not everything is going to qualify for copyright protection. First, you can't copyright a work that isn't original to you. Any creative material you acquire from others, including traditional designs or maybe stories or melodies that are passed down to you, those won't be part of your copyright. Only the new material that you contribute will qualify. So if I receive a song from my grandfather and then I add some new lyrics and maybe I change up the melody a bit, only those new lyrics and the changes in melody that I've made can be protected. Everything else will not be, or it'll be part of someone else's copyright. Second, you can only protect a work that you have written down or recorded in some way. A copyrighted work has to exist in a tangible form. Any idea for a new story or a sculpture or a dance form won't be protected unless you notate them or you sketch them or you put them in a record or a disc or a microchip or document them in some way. For example, unfortunately, jazz improvisations that aren't simultaneously recorded probably won't be covered by copyright, although some state laws might protect these kinds of performances. Third, you can't copyright ideas. You can only copyright expressions. You can't copyright a phone book. You can't copyright a language. You can't copyright a beautiful landscape or your theory of who else was on the grassy knoll, because then people can't freely share their phone numbers or speak their language or take beautiful pictures or share historical events and their ideas about them. Instead, copyright only protects expressions. It protects artistic creativity, how you arrange facts in an infographic, for example, or maybe it might protect the lighting or camera angle you use to capture that beautiful landscape, or maybe the way you narrate a particular story. These are all examples of expression, whereas the previous things I mentioned are just ideas, and those aren't copyrightable. Now, based on what we've just discussed, there are certain kinds of things that will qualify for copyright protection more easily than others. In fact, the Copyright Act specifically mentions these in Section 102. I put these in the blue box here. The problem is that not all indigenous creativity or indigenous creativity captured by visitors to our lands fits nicely into these categories. So let's think about ceremony, for example. What copyrightable works does ceremony have in it? Is ceremony copyrightable? Well, ceremony might contain songs, for example, and those are likely to qualify for as musical works under the Copyright Act. What about dance? Those would probably qualify as choreography if they're original. What about regalia? There could be graphics, graphical works that are contained in regalia, as long as they're conceptually separable from the garment itself. There may be literary works. There may be stories that are told. There may be liturgies that are spoken. There may be dramatic works, right? There may be sets of directions that people have to follow or ways of performing a story that have to happen as part of ceremony. If the authors of the ceremony take an iPhone video of it, then they very well may have captured each of these works on their phone, and maybe even created a new work, an audio-visual work or film of the ceremony as well, creating a new work. Importantly, copyright generally treats each of these kinds of works separately from one another, even if they're performed and recorded in the same microchip or on the same disc or on the same tape. One iPhone video might have 7 or 8 different kinds of works in it. Copyright owners can transfer or license the song, the dance, the regalia design, the literary work, each to different people. So you can imagine that problems might arise when anthropologists or others come onto tribal lands and document ceremonies or other kinds of cultural materials, and then begin sharing those copyrights to publishers, to record labels, to universities, or even to social media companies to whom they upload these materials. Now, to regain exclusive control over ceremonies or other kinds of works, these copyrights might have to be reclaimed and regathered again. As I mentioned earlier, copyright doesn't last forever, and here's a table that lists the length of various kinds of copyrights for different kinds of works. As you can see, the length of a copyright really depends on first when it was made and who the author or authors were, and also whether or not it was published. For the most part, though, most cultural expressions made today are covered by copyright for the life of the author, plus 70 years. That's a long time. But it isn't forever, and so Indigenous communities may need to think about other ways to protect their work, maybe using contracts with institutions, or maybe using tribal regulations. So what happens if someone uses your work without your permission while it's under copyright? What can you do? Well, if you hold a valid copyright and someone uses more than a minimal amount of the original elements of your work without your permission, you might be able to sue them for copyright infringement. And the penalty might be as much as $150,000 per instance of willful infringement. Additionally, if someone records a live musical performance of yours without your permission, that might also be treated as an infringement under the federal anti-bootlegging law. Now, even though copyright is temporary and limited, and it still might provide some protection for Indigenous cultural expressions. Increasingly, Indigenous communities are asserting their copyright rights in a variety of ways. Take, for instance, Neiman Marcus's appropriation of Clarissa Rizal's Raven's Tail coat design. Sea Alaska Heritage Institute and Ms. Rizal's heirs sued for copyright infringement, and the case was actually settled, and they were able to apply Tlingit law to resolve the dispute. The Navajo Nation likewise called out fashion retailer Madhappy for infringing their copyright in the Navajo Nation seal. Their demands that their copyright be respected ultimately led the two parties to settle, with Madhappy diverting profits from the shirts to the Navajo Nation and agreeing to hold cultural sensitivity training for its employees. So copyright can be a powerful tool to protect Indigenous cultural expression, but it's just one of many tools that are available to Indigenous groups seeking to protect and reclaim their culture. To begin to think about how copyright could apply to the collections you work with, start thinking about these 5 questions. Answering these questions will help you determine the strategy that you need to use going forward to protect and promote the work of your community.